Commission would like to next call as a witness Lieutenant Colonel Sterling Thomas. Colonel Thomas is appearing in uniform, but I think we should point out that he is not here on behalf of the United States Air Force or the Department of Defense or in any other official capacity, but as an individual. Thank you, Colonel Thomas.
Actually, I'll make one correction to that. Thank you very much for that. I'm appearing in my official capacity as the defense counsel for Mr. Omar al-Baluchi. I am an active duty military officer. I've been such for nearly 20 years of my life. I was given the mission in 2010 to defend detainees at Guantanamo, and in so doing today, I'm speaking on behalf of my client, Mr. Omar al-Baluchi, and I'll reference some of the experience of some of my other clients and men held at Guantanamo. One spin-off from that comment, in addition to defending the detainees who face prosecution before the Military Commissions Act in Guantanamo, we defend the rule of law. One other caveat I want to make, Mr. Crane, I'm sorry to cut in front of you on this. Nothing I say today is based on classified information. None of the information I'll provide to you is derived from classified information. If you ask me a question that requires that I reference classified information, I won't be able to answer it. Please don't take anything I say to either confirm or deny any information that we consider classified in the public domain.
I couldn't have said it better.
I want to thank the NCCIT for inviting me to speak here today. It is a bit of a personal opportunity. I'm a longtime resident of North Carolina from about 1970 to 1999. I was raised in Halifax County in the red clay dirt of the roads way back there where there wasn't even a town. I went to high school in New Bern, North Carolina. I attended, and I know I'm in Raleigh, but I attended UNC Chapel Hill. So if there are any heels.
Go Tar Heels.
Yeah, there we go. I also graduated, I'm very proud to say this, from the North Carolina Central University School of Law. If there are any Eagles in here, I'd love to hear from you. I practiced in the district and superior courts of the state of North Carolina for about 2 years, from 1997 to 1999. And I had the good fortune to meet a JAG whose name is Will Gunn. And Will Gunn is an Air Force JAG. And he said to me, you might want to check out some of the opportunities within the Air Force. This is not a recruiting pitch for any of you, it's just my experience. And he delivered way more than I could ever have expected. The opportunity for performance of a mission, performance of a job that calls on you to use every aspect of your training, every bit of your law school background, and serve as a warrior and officer and leader has been what I've done for nearly the past 20 years. And the training that I got at Central in litigation prepared me for that. Will Gunn, by the way, I brought him up for a specific reference. He was the first chief defense counsel for the Military Commissions Defense Organization. Mr. Gunn remains a mentor to myself. He went on to become the general counsel for the Veterans Administration, and now he is a consultant, as many retired colonels are, in the DC area. In 2010, I was asked to come to participate in the Military Commissions Defense Organization as a defense counsel. But prior to that, my primary experience in the military was that of a prosecutor. And I bring that up, it's a bit of foreshadowing for you English majors, because most of what I did from 1999 till about 2008 or 2009 was prosecute the most difficult cases the Air Force had. I've been involved in everything from putting away drug rings to prosecuting murderers. The United States versus Witt, one of the most recent murder cases in the Air Force, is one that I was assistant trial counsel, prosecutor on. That sort of work grounded me in the idea that the rule of law matters. Our discovery process in the military is open discovery. So when we have a case, the case file, with exception of, say, confidential matters between myself and an expert consultant, is turned over to the defense. I bring that up because that is not my experience since I've become a defense counsel in the Military Commissions Defense Organization. We'll talk more about that a little later. As I said at my opening, my job is to defend the rule of law, and my client's name is Omar al-Baluchi. Omar is a 40-year-old Pakistani man. He was kidnapped from the streets of Pakistan on April 29th, 2003, and rendered into the CIA's black sites for the next 3.5 years. He suffered unspeakable torture. Everything from beatings to water torture, to being shackled in stress positions for days on end, being kept awake for days on end. I mean, that's the short list. I watched yesterday, as you all heard about some of the unspeakable acts that people have committed on behalf of the United States. And I'm going to keep it brief because secondary PTSD is a real thing. As you listen to this, you're experiencing just a fraction of it, but it is horrifying, even as you talk to it, as you hear us talk about it. I've been doing this now 7 years, and I can tell you, in order to process it, you have to understand that first order, that person who experienced it personally, has it far worse than you, but you've got it bad as well. So I don't just throw these things out and douse you with it. I'm going to be very brief about these things. But one of the things that strikes me about Amar's treatment is listed in his statement. I provided a copy of this to the commissioners about his treatment when he was initially rendered into the black sites. This is an unclassified for public release statement. It's been attached to pleadings at the military commissions and released to the public, but I'll read you just a segment of it. In the end of May, early June 2003, at the CIA black site in the very first days after the US government agents shaved my head, they smashed my head against the wall repeatedly. It continued until I lost count at each session. As my head was being hit each time, I would see sparks of lights in my eyes. As the intensity of these sparks were increasing as a result of repeated hitting the wall, all of a sudden I felt a strong jolt of electricity in my head. And then I couldn't see anything. Everything went dark, and I passed out. Those are Amar's own words written on the 5th of August, 2016. Amar's been held at Camp 7, the most secret prison in the world, since 2006. Camp 7 is a rather harsh place. Some would say it's just a confinement facility, but it is a confinement facility that does not comport with what we expect, in terms of communal living for people. There is no communal recreation. There is no opportunity for communal meals or communal worship. They are kept in virtual solitary confinement with rare exception, and just enough so that they don't explicitly violate the law, but so much so that these men are suffering basically in solitary for the past 11 years. And as far as we can tell, the only consistent link between who are the residents of Camp 7 is that every person there was held by the CIA in black sites. I was asked to focus on a couple of questions today. One is, what are the past and present and lingering impacts of torture on the men who were held in Camp 7, or the detainees at Guantanamo? And the second question I was asked to address was, what are the effects of torture on the pursuit of justice at Guantanamo? And I'll address those by hitting a couple of categories. The first category is continuing allegations of torture and cruel, inhumane, and degrading treatment at Guantanamo. As I mentioned a moment ago, there continues to be what is virtual solitary confinement. If you can imagine just having no one near you except guards and closed doors, high walls, for most of your day, most of your life, with no end in sight. And folks, let me tell you, this is not post-sentence adjudicated imprisonment. This is pretrial confinement. Punishment in itself in pretrial confinement. In the military, we don't do that. Because if you're in pretrial confinement, you're considered innocent until proven guilty. So you don't get these harsh confinement facilities. But that's what we've decided to do with these men. And they live in virtual solitude. Some of the facts that have come out during the litigation that we've had since 2012, and this would be, I believe, the hearing held in 2014, Mr. Ben Al-Shib is a co-defendant of Mr. Al-Baluchi, and he has consistently complained that the conditions within Camp 7 cause noises and vibrations that prevent him from being able to sleep. Can you imagine 11 years of being constantly interrupted from any sort of restful sleep? Mr. Ben Al-Shib's testimony says that it reminds him of what the CIA did to him when he was in the black sites. Mr. Khalid Duran testified during a hearing on this very same matter, the noises and vibrations, that what goes on in Camp 7 just amounts to mental torture. And he again compared it to what he experienced at the black sites. Now, another issue that continues to raise the specter of torture at Camp 7 is the withholding of adequate medical care and torture treatment at Guantanamo. There is no reasonable denial that the United States engaged in torture of the men held in Camp 7 and virtually all of the men who have been held at Guantanamo. We've heard from many of the experts who testified before me that the Convention Against Torture requires that there be some pursuit of the torturers. But as Secretary Mendez said yesterday, there's also the requirement of some sort of remedy for the victim. That has not happened. The treatment at Guantanamo is for compliance. Just be quiet. Don't talk to me about your torture. Just be quiet. I'm not able to treat you for your torture symptoms. In fact, when Mr. al-Baluchi attempts to describe the symptoms that he has as a result of the torture that is so well laid out, even in the executive summary to the SSCI, they cut him off. The doctors at Guantanamo will not work on that. They will only work going forward. And they're not offering him torture treatment. They're offering him painkillers. So that doesn't take care of recurring nightmares. That doesn't take care of a brain injury. That just shuts him up. They treat for compliance, not for cure. One of the other obstacles to treatment is that presumptive classification still exists. It is presumed that the thoughts, experiences, and memories of the men who are held at Guantanamo and Camp 7 are classified. So if a provider were able to get to Guantanamo, then they would have to have a top secret clearance, be read into every ticket that these men might have experienced when they were being tortured by our government. And then that client, that provider might be able to hear from Amar about what happened at Camp 7. But what holds that up? The government doesn't grant an independent psychiatrist access, but with rare exception. And I can point one out to you. There was a brief opportunity for Mr. al-Baluchi to speak to an independent psychologist some years ago. It was one of those rare moments where the stars aligned. But he was never given an opportunity for follow-up care, and that psychologist was never permitted to do more for him. And what that individual learned during that treatment, or that opportunity, was that he had signs of brain damage. He had signs of traumatic brain injury, nerve damage, memory loss, all manner of deterioration that, again, I don't want to overwhelm you with just how bad it is, but the medical records are, in many cases, classified. But what I can share with you is the impact of what happened to him between 2003 and 2006, the torture conducted by the United States, continues to cause his mental and physical deterioration. The nerve damage caused by his shackling when he was put in stress positions or locked up for long hours of transport on aircraft that flew out of North Carolina, that has caused nerve damage. We've been seeking for 7 years now, as his legal representatives, to have a magnetic resonance imaging done, an MRI. And to date, the government has not permitted that to happen. Now, after I think 6.5 years of effort, we finally managed to convince them that you should at least get an MRI onto the island. But now I believe their current issue is that they can't maintain it. And they don't have a date when they can even get it to work. But still, men like Mr. al-Baluchi and Mr. Nashri suffer from the damage done to them nearly 15 years ago. And we haven't even allowed the study of the impact of that on their brains. But what has happened is they've begun the prosecution of these men. I go to Guantanamo pretty frequently, and I thought that fresh data might be most useful for the commission. I was in Guantanamo as recently as the 18th of November. I'll be in Guantanamo tomorrow night, and I will meet with my client again. When I spent the last couple of weeks with him, I can tell you that physically, this man who was kidnapped in his 20s, and who just turned 40 this past summer, he looks older than me, and I'm approaching 50. He looks more tired than me, and he looks like he is deteriorating. A man who had at one point the ability to speak English, Arabic, was a person who had worked in the computer field, had difficulty staying focused during a 3-hour first session interview with me, such that I had to actually make him take breaks so that I could continue asking a simple question about medical records we were reviewing. That sort of mental deterioration, I think, might happen for me because I'm just tired, but for a 40-year-old, that shouldn't be the case. Another issue that arises is the failure to investigate current and previous allegations of torture or allow the independent inspection of the facilities at Guantanamo. Mr. Mendez and others have hit this very eloquently. In order for us to be able to assess the status of the facility, it cannot be some dog and pony show. It's not something that we want to send down just so a congressman who's seeking re-election sees all the nice things that the really dedicated men and women do down there. That's not what it's about. It's about the opportunity to speak with the individuals who are imprisoned and see the prison itself without the United States government trying to shade what is going on and what's happening there. They're not permitting that, and thus there is no independent investigation of the facility. That's been prevented now for, I believe, more than a decade. And someone used the word yesterday that I think I'll adopt, exceptionism. If I were talking about another country, and I've been to some of the places where these things happen, everyone would poo-poo it and go, that is just a shame that happens in that country. But we're different. Well, we want to be the exception. The rules don't apply here. That should not be allowed to happen. If we're going to uphold the rule of law, we have to apply it to ourselves just as much as we would apply it to someone else. Another area I want to touch on is the failure to investigate I'm jumping backwards here, the torturer's impact on seeking justice. Why don't we go to my area, the rule of law. The 2009 Military Commissions Act permits the use of torture-derived evidence. For the law geeks in the room, you're going to love this. For everyone else, hang on for just a minute. The 2009 MCA governing the entire military commissions system at Guantanamo allows for presentation of torture-derived evidence by the prosecution. Section 948R, Romeo, provides the following: determination of voluntariness. In determining for purposes of subsection C2B, Charlie 2 Bravo for the military, whether a statement was voluntarily given, the military judge shall consider the totality of the circumstances, including, as appropriate, the following: the details of the taking of the statement, accounting for the circumstances of the conduct of military and intelligence operations during hostilities, the characteristics of the accused, such as military training, age, and education level. And here's the kicker: the lapse of time, change of place, or change in identity of the questioners between the statements sought to be admitted and any prior questioning of the accused. Folks, the reason this language was added is that following the extended torture and detention of these men in torture facilities by the CIA, they were reinterrogated by what's called clean teams. After a period of sitting still in a room, they were told, now we're going to talk to you again. We're not the same guys who were poking you and prodding you, torturing you. Tell us what's going on. What they want to use is a temporal argument and saying that we've gotten far enough away from the torturers and their acts, now you can trust us. But it's the same US government. They're in the same kind of facility. And they haven't been treated for the very torture that put us in this position. So what has happened so far is that in US versus Nasri, in August of this year, the government took the position that this temporal argument would permit them to use torture-derived evidence gained by these clean teams. And I predict for you that either in the hearing we have next week in Guantanamo or in a subsequent hearing in January, the United States in the 9/11 War Court will attempt to do the same thing. One of the most egregious things that a prosecutor can do in military courts martial, in federal courts, is to withhold evidence from the defense. I have always prided myself on being the kind of attorney who could walk in, look at a case file and go, that's garbage, that's good, here's the entire case file, see you in court, I'm going to kick your butt. That's the kind of prosecutor I was. I was nice outside of the courtroom. But I didn't hide anything. And that was the practice I was taught. Give them the case file. It doesn't get better with age if it's bad news, so get the stink out there in front. In fact, I would present it. Hey, investigator so-and-so made the following mistake, and let's address that right now. And then, here's what the government got right, and here's why we're still pursuing this case. It's not where we are here. We're not really dealing with what I would consider open discovery. Anecdotally, I was approached 2009 timeframe to come be a part of the prosecution for the military commissions. And I talked to my mentors. It's always smart to go talk to a colonel if you can find one, about what was the wisdom, what were the issues that might be related to becoming a part of the prosecution. And my mentors explained to me, one of the big challenges for the prosecution in this case is that they have 30 different masters, and they're all intelligence agencies. And intelligence agencies have zero interest in prosecution. That is not what they're about. They're about the gathering of intelligence. You're engaging in a law enforcement function, they're doing intelligence. If you don't sync up, and that Venn diagram does not overlap everywhere, where you don't sync up, you lose. And what I've watched as a tactical and strategic thinker and a prosecutor is that often the prosecution is handicapped by their masters in the 9/11 case because they cannot own the file as I would have when I was a prosecutor. There was no investigator who could just walk away from me and say, I'm not going to talk to you about this case, or you can't have this evidence. The best I can see is that that is a challenge for this prosecution. And in so doing, we end up with situations like this. We're investigating black sites. We have a hearing about a protective order, preserve the black sites. It is now publicly released knowledge through the military courts that a black site was destroyed while under a protective order. Black sites contain mitigation evidence. Black sites contain forensic evidence, and we will never see it. But the government was aware of and sought this destruction order while this protective order existed. That's the kind of thing that's happening in our 9/11 war court. Other instances of the government's, on the one hand, wanting to bring in evidence of torture through torture-derived statements, and on the other hand, trying to keep that information away from the defense. For many of you who watch this sort of movie, perhaps you've seen Zero Dark 30. Can I get a show of hands of who might have seen that? Okay. I can't watch more than 30 minutes of it. One, probably because of the work that I've done, I've gotten oversensitized to this sort of thing. But two, the person who is depicted in the first 25 minutes of that movie is my client, Amar. And it depicts, from according to the publicly released and unclassified records, a description of horrific treatment of Amar. Doesn't get into it all, but it's bad enough. We asked, how did this individual, Ms. Bigelow, the director of Zero Dark 30, get all this information? And received in discovery that she had access to CIA records. The CIA wanted to help her make this beautiful presentation of how they went about their work. It includes some factual and rather graphic inaccuracies, but they used that information, and we asked for the same sort of access. A movie director gets greater access than a defense counsel, because we're denied because they say it's not relevant. Those sorts of gamesmanship, hide the ball, is just not what will go forward. But the reason for it is it's related to torture. And that is embarrassing to the United States government. One of the other two issues I want to bring up, actually there'll be a third as well. I mean, lawyers always want to add something else, right? Appellate Exhibit 424 is a motion. We use this jargon, and I apologize for it. Military guys get caught up in jargon. But 424 is a motion that tries to prevent the defense counsel from conducting domestic investigations within the United States or its territories of individuals who participated in the torture of our clients or who saw it. 424 tries to close this out domestically. AE 525, a current live motion, is the government's international effort. They're now trying to prevent us from going to the places like the black sites or the countries where this occurred and talking to the people who would know what happened at these secret prisons. They want to shut down the international investigation of torture. So this, again, is about preventing the investigation of this heinous period in our history because it involved torture. And one other point I want to make is that this is high stakes stuff. We have, this doesn't necessarily hit directly on torture, but it hits on the stakes for the participants within the military commissions. Guantanamo has most recently had its newest resident. Some of you might not be aware, but an American citizen was confined within the past month on Guantanamo based on actions taken in the Nasri War Court. Brigadier General Baker, who is the Chief Defense Counsel for the Military Conventions Defense Organization, took a stand saying that a learned counsel must be present during a death penalty case. And the judge, Judge Spath, whom I've known for a decade, disagreed with him and held him in contempt. A Marine general went to jail to protect the right to counsel for a Nasri, a capital detainee. Those are the stakes we're dealing with now. It is important that we all push as hard as we can in every facility and every capacity we have to make sure that we protect the rule of law. And here is how I'm doing it. What I want to reflect back to you is my appreciation for all of you in the NCCIT, those of you who are watching, perhaps students getting ideas about what it means to defend the rule of law, what it means to apply the rule of law equally, no matter the situation, and most importantly, when you are challenged. I want to thank the NCCIT because it's a citizen-led effort, and it takes a groundswell of things like this to get the attention of people who are looking for polling stats, not moral values. If you live by your values, you'll be all right. If you live by the latest Harrison polls, I'm not sure you're going to do so well. So when we say we're worried about people advocating or being comfortable with torture, we need to continue working in this area to raise the knowledge of it doesn't work. It corrupts us from within. And it is one of the worst crimes you can commit. And making excuses for it, as I've heard several times, and I endorse this, make it even worse. Thank you, and with that, I would offer questions.
Thank you very much, Colonel Thomas. Commissioner Daskell has a question.
Thank you, Lieutenant Colonel. I wanted to know if you could talk a little bit more, to the extent you're able to, about the conditions in Camp 7 and what the detainees there are experiencing currently.
Unfortunately, I can't get into significant detail about the conditions in Camp 7. I can tell you this much, Commissioner Daskell. There have been very few attorneys, defense attorneys, who've been permitted to even go into Camp 7. I believe an ICRC visit might have been done, but they're not free to disclose what they've done there. But in the good fortune of pursuing this issue before the military commissions, my co-counsel, Mr. Connell, was one of the few counsel who's actually done a site visit in the most classified prison in the world. Unfortunately, I can't give you the details of that visit because it remains classified.
Colonel Thomas, let me ask you a question. A more general question that arises from the one that you just asked. It's been a few years since I was at Guantanamo. I represented some detainees myself, and I remember that the administration at Gitmo was not exactly welcoming to defense counsel in terms of arranging the visits with our clients. And there were things like transporting the clients in a very uncomfortable position, subjecting them to very intrusive bodily examinations before they were brought for a visit, leaving them shackled for a long time in an interview room before we were permitted to enter, taking so long to review the materials we had with us, if we had any, that it truncated our time to interview them, and so on. And perhaps listening in on the conversations, although we had our suspicions about that. I would like to hear you address whether or not any of that has changed, or is that still the same situation?
So thank you for your question, Commissioner. Many of those problems remain. It really depends upon the guard force and how they intend to apply the rules from time to time. It's like going to meet a new DA. He's trying to prove himself initially, and then he figures out, oh, this is where I need to really apply myself, and these other areas I can sort of work it around. The guard force has a standard operating procedure. They go in, they're very afraid when they first get there, then they try and apply everything by the letter or even over-apply the letter of the law, and then they finally realize, oh, there's common sense involved. And that normally takes about 6 months, and then they rotate out. And one point that you hit on is whether they're listening in. There are a series of things that I have not brought up that are not classified, but are incidents that would just shock the conscience of those of us who've practiced in federal and state courts. And one of those is the discovery of listening devices in the attorney-client meeting rooms. I mean, some of you have heard about this. But I was meeting with my client from 2010 until currently, and I remember going in there initially and seeing a smoke detector right beside me. I thought, that is an odd placement. But turns out, and this has been cleared through the military commissions, that yes, those smoke detectors were not in fact smoke detectors. They were listening devices. The claim is that they were never turned on during our meetings with our clients.
Yes.
But, yeah. I got a bridge in Brooklyn. Anybody interested? All right.
Thank you very much. Commissioner Crane has a question.
Thank you, Colonel Sterling. We haven't seen much moral courage here this morning, but I think that you have stepped up and put it back on the right road. And being a former judge advocate myself, you make me proud of being having been a judge advocate, and I appreciate your service here. Could you give us your perspective on the defense of superior orders and following illegal orders?
I listened to the prior presenter, and I have great respect for my brothers in arms and brothers and sisters in other branches of the government, but I disagree with the we shouldn't prosecute. It requires a accounting for those actions. And while it will offend some people, I'll harken back to the Reconstruction example that was offered. Had we taken a different tack with some of the treasonous behavior of those who chose to try and divide our country on the basis of slavery, who then, within, I'd say a decade, at the most 20 years later, came back and said, well, we're going to make sure this supremacy that we lost under war comes back again. Had President Lincoln dealt with those people more severely, then the death of Reconstruction might not have occurred. And we might have a different America right now. We might not be 50 years behind our brothers in the UK on issues like slavery and integration and interracial marriage, but here we are because of a choice made 150 years ago.
Would you agree with me that those who would you agree with me that those who follow illegal orders are also committing the same crime?
Under the law of armed conflict, you cannot obey an illegal order. And the common example that's given to us is you have an enemy combatant held prisoner. He is helpless. He is confined. He's cuffed. And your superior comes to you and says, put a gun to his head. We're too busy. We can't carry this guy. Kill him. It's as easy as no. No. And if he attempts to enforce that order, then you have an obligation to make sure he doesn't.
Thank you.
Thank you, Colonel Thomas. Please join me in thanking Colonel Thomas. All right. We're really tight on time.